Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Welcome to another episode of Time is Not on Your Side. I'm Robert Eckard, board certified business litigation attorney and government investigation specialist. Today's topic, demand letters, protecting your rights, settling disputes, and setting the stage for effective strategic litigation. A well-written demand letter can be your best friend in first step in resolving a business dispute. When business relationships fall apart, it can be challenging to know what to do next. Perhaps a contract has been breached, someone owes you money, or you're involved in a shareholder dispute, or intellectual property is being infringed. Whatever the issue, a carefully drafted demand letter is often a first smart step in a resolution. A demand letter is more than just a request, it's a statement of intent. It shows the other party that you're serious, prepared to sue if necessary, and likely to prevail, and why. It also makes clear that ignoring your demand will cost them far more than resolving the matter now. While you might be tempted to write the letter yourself, having an experienced attorney draft it can make all the difference. And here's why demand letters are so effective and why they're worth doing right. First, what exactly is a demand letter? A demand letter is a formal written request asking another party to resolve a dispute, comply with an agreement, or remedy a legal violation. It lays out the problem and explains your legal rights and specifies what needs to happen to avoid further litigation. But a demand letter is more than a formality. It's a strategic tool that can often prevent costly litigation. If ignored, it can serve as key evidence in court, demonstrating that you made a good faith effort to resolve the dispute before litigation, often becoming an exhibit in the complaint filed with the court. Second, what makes a strong, effective demand letter good? A well-drafted demand letter achieves at least four critical objectives. First, it communicates strength. It shows the other party that you're prepared to take the matter to court and that you're ready to do so right now. Two, it emphasizes consequences. It makes clear that litigation will cost the other party far more than resolving the issue now. Three, it demonstrates professionalism. It uses precise legal language, references the specific contract, provisions that have been breached, or other fact-specific references in the case, and it cites the applicable laws and avoids emotional or inflammatory statements. And four, it provides a real solution. It offers a practical path for resolution. For example, if the other party cannot pay the $200 million, or $2 million demanded immediately, the letter might propose an installment plan or other feasible alternatives. A well-drafted demand letter signals that your position has been carefully considered and supported by legal expertise and authority. It sets the tone for productive negotiation or lays out the groundwork for litigation. All right, 3 reasons why you shouldn't draft the demand letter yourself. It's tempting to save money by writing your own demand letter, but this approach is often counterproductive, and here's why. First, non-lawyers often fail to include essential details or frame their arguments effectively. For instance, we had a client whose self-written demand letter was completely ignored. Upon our review, we discovered that they had omitted 3 critical provisions of the contract. One, the interest rate accrued at 18% per year on unpaid invoices. 2, that the contract contained a prevailing party clause entitling our client to attorney's fees. And 3, the jurisdiction in which the lawsuit would have occurred would have been of ours a more favorable one than the out-of-state defendant. So we redrafted the demand letter with these 3 additional key points, and within several weeks, the case was resolved without filing the other lawsuit. Second, The second reason you shouldn't draft your own demand letter is because typically emotions run high and it's easy to write something overly aggressive or inflammatory, and this can often backfire. The letter written by an experienced attorney strikes the right balance between firmness and professionalism. And the third reason why you shouldn't write the demand letter yourself is because a letter from an attorney typically carries more weight. It signals that you were serious and ready to act. Many clients have told us that receiving an attorney's demand letter made them realize delay or ignoring the issue was no longer an option. Do demand letters always work? No. The letters don't always work, and they're less effective now, I believe, than they were 10 years ago. However, they remain a valuable step in most cases. Here's why. The time spent preparing a demand letter is never wasted. Nearly every minute of research and analysis that goes into drafting the demand letter can be repurposed for drafting a complaint if the matter escalates to litigation. If there's a chance the demand letter might work and you're ready to sue, if it doesn't, sending one almost always makes sense. When properly drafted, a demand letter can save significant time and money compared to litigating a case where both sides are bound by the court's calendar. Several examples of demand letters in real life include, first, in a breach of contract case. We had an IT company abandon a project halfway through on a client. Instead of immediately filing a lawsuit, we sent a demand letter outlining the breach, citing various contract provisions and cases, and giving the IT contractor a deadline to remedy the situation. The result? The IT contractor hired a lawyer and we worked with that lawyer to get the project back on track with some new guidelines in place. The IT contractor resumed work and completed the project, avoiding litigation. Amazingly enough, our client hired them again for another project. Example 2, trademark infringement and unfair competition. A competitor of a client of ours started using a logo nearly identical to one of our clients. We sent a demand letter citing trademark and unfair competition law, demanding the competitor immediately cease using the logo and proposed a monetary settlement. The result was the competitor immediately agreed to stop using the logo, pay all of our attorney's fees, and offered our client a hefty percentage of proceeds from the remaining inventory with our client's logo on it. Our client accepted the offer, and though it was less than they would have likely gotten had they sued, it avoided a costly lawsuit, gave a quick resolution, and mostly achieved the desired outcome. In conclusion, whether you're dealing with a breach of contract, intellectual property infringement, and unfair competition, or another legal dispute, a professionally well-drafted demand letter by an experienced attorney can be a powerful tool. It establishes your position, encourages resolution, and often avoids the need for litigation. This has been another episode of Time is Not on Your Side. If today's topic was helpful, I'd appreciate you hitting the like button. You can find other episodes on www.roberteckardlaw.com and all the major platforms, including YouTube and Spotify. I'll see you next time. I'm Robert Eckard.
You've been tuning into Time is Not on Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.